physical evidence is that it tells a story. We look at the firearm, we look at the blood, there were cartridges left behind, projectiles were found within the toilet. Physical evidence cannot lie.
Welcome back here with Channel 199. I want to address the issue now of the double tap, because when Chris Mangena was in the stand, under cross-examination by Barry Roux put it to him that the defence case would be that Oscar Pistorius shot using double tap. Bang, 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 bang. Then suddenly he stood up and said, I am advised that that is not the defence's case, which prompted Reneer to immediately get up and say, well, I'm now going to cross-examine the witness, now understanding there wasn't a double tap. Did something go wrong here? What's your understanding of what possibly could have happened here, James?
I'm looking at you, James.
I've got some.
I'll be the one who says yes. I think so. I think that they should have been upfront about what their version was going to be, and if it was going to be that that it was a rapid succession fire, that should have been disclosed up front, because of the way in which then Reneer would have had been allowed then, or been able to address that very issue by his expert witnesses. He's now put in a very difficult position where suddenly he's having to respond to this. But rightly, as he points out, now being able to cross-examine the defence's witness on this, how exactly is that supposed to make any more sense? If you're saying to me that on the original version, double tap, where there'd be some time between them, now you're saying rapid fire, where there would virtually be no time. The victim is supposed to be falling during this time, so your evidence doesn't make sense. It's not possible for it to have been rapid fire.
Again, my learned friends are very courteous about this, and it's been evident during our conversation what the approach is. Come on. You never, ever want to expose your client to cross-examination. Sir, your counsel, on your instructions, on this very, very important issue, made certain very clear statements. Is that correct? You were sitting in court when this happened. Did you raise your hand and stop him and say, but listen, Advocate Roux, that's incorrect. So what happened in the meantime? Did you change your version? Was it an incorrect statement? It is, with respect, David, completely unacceptable. We've established before we came into studio the double tap, because we were so amazed at that change or that apparent change in the version. So, no, definitely that is unacceptable.
Chris?
Well, David, you remember that on this program, I mooted my bemusement.
Yes.
And I stuck my neck out and said I wondered how Roux was going to follow through on this allegation of double tap that was put to Captain Mangena. This is not good, because whatever Roux does in court is not something that Roux has dreamt up. The public needs to understand this. Oscar tells Roux what his case is. And I agree with my colleagues. It's very difficult to understand why Roux put that as an express allegation to an important witness, and it's even more difficult to understand, if that was done in error, why it wasn't corrected immediately after an adjournment or soon thereafter.
We may hear more about this under cross-examination. Let's have a look at some of the tweets that have been sent to us using the hashtag roundtable199. We had some very interesting issues that were raised. Let's get those tweets up. There we go. If Oscar's already been filmed throughout the trial, why would he have the option of not being filmed while testifying? Anybody want to have a stab at that one?
Yes, please. With the greatest respect, I don't understand this at all.
I think I do.
Oscar, as a human being, stood up to the whole world and said, I want to be accepted as an equal, that I am not disabled, and that I can compete with anybody on any terms as an equal. And more particularly, he has profited greatly, immensely, in that stance and in that acceptance. So I cannot see how now, when he needs to account for the death of another human being, suddenly it becomes inconvenient suddenly it is, that degree of publicity is no longer acceptable to him. I don't accept it.
I was going to go on the strict letter of the court order by Judge Mlambo. None of the defence witnesses are going to be filmed, and he is a defence witness.
You know, it's kind of a security blanket. In circumstances where it's clearly very difficult for him to testify already, I think it's just that little lollipop to say that at least you're not going to be filmed.
Okay.
There's also one last consideration, the right to a fair trial. Right? Every other accused doesn't stand filmed before the world in South Africa right now. And all he's asking for is to be treated equally.
Is Kerinel's continued sarcastic tone allowed in a court of law? I was wondering how quickly the criticism of Kerinel was going to come. Nobody's objecting.
Yes, look, the Constitution guarantees that you'll be treated with dignity and respect, but cross-examination is the most valuable tool to test evidence, and the court will most definitely allow certain leeway in using that instrument. The court is not going to allow Kerinel to overstep that bounds. So to answer that question, most definitely it is allowed.
And you've got two policemen on this one, haven't you? You've got, well, Barry Rue is the guardian angel, and you've got the policeman and the judge saying,
absolutely,
rein it in.
Yeah.
Why has the state not gone to any area of establishing a motive or asked why Reva locked the toilet door? From Eric. Anybody want to have a go at that? I think that'll all come up in closing arguments.
What is the question?
Why has the state not gone to any area of establishing a motive or asking why Reva locked the toilet door?
Well, the only witness to the actual killing is Oscar himself. And I think what's going to happen is that Kerinel will impute motive to Oscar when he cross-examines him.
I think important also to note is that the court is allowed to draw reasonable inference from proven fact. If it's proven that the door was locked, the court may, on the totality of the evidence, draw inferences as to the reason why the door was locked.
Okay, that is something that possibly will get answered later under cross-examination. How's Oscar's biography going to assist? I think we've answered that one. We've spoken about establishing, presenting Oscar to the court and allowing, and then also establishing where this concept of fear comes from and the evidence of the crime that he was subjected to. And the last one, does the defence pay their expert witnesses for their service and their testimony?
Yes, they do.
Okay, yes. As simple as that. Yes. I think that's unfortunately it. Chris, I know you did have something to raise with us about the question of if Oscar gets caught on a lie. You know what, you're going to hold it for our next panel discussion.
Okay.
Which does mean you will be back again, but you knew it, as all three of you are. Chris, Reneer, James, thank you very much
for having us.
As always, an absolute pleasure having our guest there, former Zimbabwean High Court Judge Chris Greenland. We had Defence Attorney Reneer Spies. We had Wits University's Professor James Grant with their insights and their participation. We'll have more debate from the roundtable tomorrow evening at 8 p.m. Stay in touch with me via @OscarTrial199. Send your questions that you'd like the legal panel to address using that hashtag roundtable199. We do want to hear from you. If you're not in front of your TV, remember, Channel 199 is available online to qualifying DSTV subscribers, and that full channel is available 24/7 via live streaming to PCs and laptops at oscartrial.com. It's also available on your walker. From me, David O'Sullivan, good night. It's now over to Katie Katapodis.